in recognition of child marriage, Section 29, subsection 4B of the Constitution states that any woman who is married shall be deemed to be of full age. Now, the Constitution Review Committee of the Senate had rightly recommended that Section 29, subsection 4B of the Constitution be deleted, as citizenship has no bearing on gender. As a matter of fact, if we talk of gender and we are talking of civil rights, we are talking of citizenship, we are talking of civil rights of both the man and the woman. And therefore, there is no basis to differentiate between gender in that section. In his contribution to the debate on the matter, Senator Ahmed Yerima argued against the removal of the clause on the ground that it is against Islamic religion. As a matter of fact, he went on to whip up sentiment on Islamic religion, according to him, stipulating majority age for women under Islam is not allowed. Now, the senator led his colleagues to believe, erroneously, that once a girl child is married, she automatically metamorphoses into an adult. To that extent, she is capable to make an informed decision on renunciation of her citizenship. In other words, as soon as a child is married, even if she's 12 or 14, that affects her mental capability. In other words, even where she's mentally immature to take decisions on different matters, the fact that she's married already qualifies her as an adult. Surprisingly, the Senate agreed with this misleading contribution of Senator Yerima and proceeded to vote against the recommendation that the controversial clause be deleted from the Constitution. Having married a 13-year-old Egyptian, I'm sure we still remember, in 2010, in contravention of the Child Rights Act, and I will get there soon, without sanction, Senator Yerima was encouraged to lobby the Senate not to delete Section 29, subsection 4B of the Constitution, which has recognized child marriage. In rejecting the recommendation, the senators did not avert their minds to Section 42 of the Constitution, which has abolished discrimination on the basis of political opinion, place of origin, ethnicity, sex, or religion. Now, the Senate failed to appreciate that the Child Rights Act 2003 has also prescribed 18 years as minimum age of marriage in Nigeria, in line with the provisions of the United Nations Convention on the Rights of the Child, which was ratified by Nigeria in the year 2001, and therefore binding on us as a country. Now, the attention of the legislators who believe in child marriage should be drawn to Section 23 of the Child Rights Act, which is a national law, and it provides thus: a person who is married, who marries a child, or to whom a child is betrothed, or who promotes the marriage of a child, or who betroths a child, commits an offense and is liable on conviction to a fine of 500,000 or an imprisonment of a term of a 5-year term, or both such term and imprisonment. In other words, if Senator Yerima had been prosecuted, he would have earned himself a jail term of 5 years or a fine of 500,000. But I also want to note, we will get there soon, that when we talk of crime, there is no limitation to the time which a criminal can be prosecuted. In other words, Senator Yerima, as we shall soon get there, can still be prosecuted, and we call on the Attorney General to begin the process of his prosecution. Now, the Child Rights Act, which is applicable in the Federal Capital Territory, has been adopted in 24 states. In other words, out of the 60 states we have in Nigeria, 24 states have gone to, they have taken steps to enact the Child Rights Act into child rights law of their respective states. And apart from Enugu State, which is in the south, all others states that have not enacted the child's rights laws are from the northern parts of this country. And sadly to note that these states are Sokoto, Kebbi, Zamfara, which is our Senator Yerima state, Katsina, Kano, Kaduna, Bauchi, Gombe, Yobe, Borno, Adamawa, and Enugu states. Perhaps these states also believe that children deserve no rights under the law. Now, the right child's law have been passed in Ebonyi, Kogi, and Niger states, but the laws are awaiting governor's consent. We are therefore compelled to make this disclosure as it is the law in this country, precisely Section 15 of the Child's Rights Act and Child's Rights Law of these respective states, that there is a duty imposed on the government to provide free education, free and compulsory education from primary to junior secondary for every child. The age of 1 to 18 is a school age and not a marriage age. This is the age that a child should be in school and not in a man's house as a wife. Thus, by not adopting the Child's Rights Act, the aforementioned states have continued to promote child marriage, child labor, illiteracy, and ignorance in this country. Now, looking at Section 29, subsection 4b, it will be discovered that even beyond child marriage, the judicial interpretation of that section goes more, even far more beyond child marriage. Regrettably, the interpretation of that section is that any girl child who is married is deemed to be an adult and can therefore be presumed to have right to vote. You will agree with me. So if a 12-year-old girl is married, she's entitled to the right to vote. That is the implication, the judicial interpretation of that section. She's also presumed to have criminal liabilities, contractual liability. As a matter of fact, she has capacity to sue and be sued at that age. And of course, she's presumed to be a full age. She can even go ahead to write a will at the age of 12. That is the dangerous implication that nobody has gone ahead to even look at all. We've been talking, and if Senator Yerima and his colleagues are talking about Islamic applications, Islamic law, I want to remind him this time that I think chapter 4, verse 16 of the Quran specifically talks about the Sahar. The Sahar is the mental immaturity of a child. In other words, if a child is given a right of inheritance, she is not mature, at the age that she's not mature, she doesn't have mental maturity, the property is held in trust for her until she attains an age of maturity. Apart from disrupting the education of the girl child, early marriage constitutes a danger to her health. It has been medically ascertained that incidence of VVF, viscovaginal fistula, this is a disease that is prevalent in early marriage. It is the tearing of the vagina to the bladder. Because the vagina at that age is largely immature, it is not ready for the production of a baby. And so when a baby is forced out of it, it tears and opens up to the bladder, to the urine bladder, and urine flows directly into the ovary. And the girl begins to rotten and begins to smell. Eventually, the allergy dumps her. Because when she begins to smell, the end result is that the allergy dumps her. And also, sadly, also to note that there is this very discriminatory and very callous way, or a way of a right of divorce of the man in the Quran. The man has the right to say, I divorce you, I divorce you, I divorce you. While the woman does not have the right to pronounce that. I don't know what they call that. Talat, talat, talat. And therefore, as soon as the girl begins to smell, Alaji just goes ahead to say, talat, 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 to your tent, O Israel. Go and rotten, go and die. And that is the end of the poor girl. It is unfortunate, but I say it is wicked and it is callous. What is the hope of a 30-year-old girl who has been forced into marriage? Now the law has criminalized marrying or giving your daughter out, an underage girl, daughter out in marriage. In other words, you as a parent, if you give out your daughter that is underage, you are committing a crime and you can be sentenced to prison. Now your daughter has the right to say no, because she has the right to freedom of association. It's a fundamental human right. It's there in the child's right law. In the light of the foregoing, we call on the Senate to review its dangerous position and vote the deletion of Section 29(4)(b) from the Constitution. We also call on the 12 states that have not adopted the Child's Right Act to do so without any further delay. Finally, we call on the Attorney General of the Federation and the Minister of Justice, Mr. Mohammed Adoke SM, to ensure that Senator Ahmed Yerima is prosecuted for violating Section 23 precisely of the Child's Right Act by marrying a 13-year-old Egyptian girl in the year 2010. There is no time limit to which you can prosecute a criminal. We say Yerima deserves to be prosecuted, and I also want to add that if the Attorney General does not take up this prosecution, Women Empowerment and Legal Aid will not hesitate to apply for a private fiat. We will apply for a private fiat to prosecute this man under Section 23 of the Child's Right Act.